And inevitably, in your own word, it sounds like they end up having to take care of the trust and what they were trying to avoid all along, which was the probate. Am I understanding that right?
Right. Yep. Yep. That's a very
Yeah.
good summary.
So how do we fix that? Welcome back to another edition of Retirement FAQs. I'm delighted to be joined by Robyn McGinnity today, an estate planning attorney with over 16 years experience who has 3 beautiful children and one of which is going pro in soccer in Peru this year. And today would like to highlight a few key misconceptions she comes across with her clients and wants to clarify. Robyn, thanks for joining us today.
Thank you. Appreciate it, Taylor.
Yeah.
Yeah, as you and I have talked about before, I think it's probably easiest for us to start now in just explaining what is estate planning. I think most people actually don't even know what that means. And when we talk about estate planning, I like to describe it as creating a tool belt for people to plan for potential what would happen to their assets at death, and then also what would happen if they were incapacitated for some reason. That can include doing wills, trusts, powers of attorney, that kind of thing, succession planning for their business. It incorporates a lot of areas of law because of what we do, but the umbrella for that is estate planning.
Fantastic.
Yeah. And I think I can just start going through some of the misconceptions that I've come across in meeting with clients and talking with people. One of the misconceptions that comes up is that estate planning is only for the wealthy. And I would say that's definitely not true. A lot of the reason to create an estate plan is to eliminate any indecisiveness after someone were to become incapacitated or pass away. If you have a plan in place, a court is going to defer to that plan, and the plan will be much more efficient as we or your survivors are trying to put that into place. So you don't need to be the very wealthy in order to have a great incentive to do it. If you don't do estate planning, then default rules are in place, but that doesn't mean that those default rules are ones you want. So obviously, we would encourage people to take the time to investigate what they would like to have in place. And I think those are, even a 1 hour meeting is a very productive meeting to go through that and help explain it. Another misconception that comes up is probate. Yeah. There's so much misinformation out there about it that I like to clear that up pretty quickly in the meetings I have with clients. It's thrown around these days almost like it's a swear word or it's something like the plague to be avoided at all costs. And that's really not necessarily true. For one, it really depends on which state you are a resident of or the deceased was a resident of at the time of their death. That state's laws would apply. And thankfully here in Washington, I also practice in Idaho, the probate process there is not unduly burdensome, expensive, time delayed, which would be a lot of the reasons that people would otherwise seek to avoid probate in other states. For example, an easy example is California charges, I haven't checked recently, but I understand them still to charge a percentage of the value of the estate, and that their probates typically take many years to be resolved. So people down in California usually have a much greater incentive to try and use different estate planning tools to avoid the probate process than we do up here in Washington and Idaho. What we find here in Washington and Idaho is that even for very small estates or people worth hundreds of millions of dollars, the core probate tool that we inevitably use is actually a will. And when we talk about the probate process, that's really just the mechanism where the will is filed in court. The appropriate people are appointed to administer that. Creditors' claims period runs so that any creditors can be paid and those issues can be resolved. And ultimately, all the assets are distributed as provided under your will. It's really, if you have an estate plan in place, it's a very efficient process here in Washington and Idaho. If you don't have a plan in place, then unlikely very efficient, but it's all that to say probate is not to be avoided like the plague. So I would like that information to be shared for sure.
No, that's very clear. Thank you for highlighting that. As I've heard before, maybe you have too, if you fail to plan, you're planning to fail. And in many cases, you don't want to have a failure plan in place when it comes to incapacitation or much less upon your passing for your heirs and executors to deal with. Maybe you could humor me, Robyn. Let's pretend we have some fifth graders in the audience today. And if we break down probate just a little bit for me in the audience, if I'm an executor having to prepare or I'm thinking about my children as executors in the future, what is that process that they can expect for that probate? Does that make sense?
Yes, very good question. Yeah, so the probate process would be basically we'll assume somebody has a plan in place and go through that scenario
Yes.
first, at least. There would be a will in place, and under that will, the person would have named their executor or personal representative. Different expression, that means the same thing. And that person is the person charged with administering that person's will. So, what the person needs to do is to start the process by getting a probate action filed in court. And to do that, they would go to estate planning / probate attorneys such as myself. And I would draft the paperwork for them, file it in court, get them the necessary letters testamentary, for example, which are the evidence to the rest of the world that they have the authority to administer those assets. And then they can start that process. In addition, what is usually a component of probate is that a notice is published in a local newspaper that the person has passed away. And then creditors have a certain time period, usually about 4 months, to reply with any claims. And if they don't, or they don't do so correctly, they are forever time barred from bringing a claim against the estate. So that's actually one of the really nice features of probate. You get full and final resolution of claims so that whatever the beneficiaries inherit, ultimately they can have high degree of confidence that they can go about their merry way with those assets and not be concerned about anybody coming to collect against them later. So, as part of the probate process, what we do in our firm, we are basically holding the hand of that personal representative / executor throughout the process, advising them what they can and can't do, should do, timelines, and ultimate resolution, and filing all the corresponding paperwork to go with that. So thankfully, an executor doesn't need to also be an attorney and know all of these things. They can hire somebody to help them out and make the process pretty straightforward.
Okay.
Yeah.
That makes sense. Thank you. So to be clear, this is something that an ordinary Joe, for example, could jump in and initiate and walk through the entire probate process on their own. But if they're intimidated about the process or concerned about making a mistake or overlooking something, they can just outsource it to someone like you to handle through for them.
It wouldn't be outsourcing, it would be a companion in the process. So
Okay.
we would handle the legal paperwork and they would do the administration. So, for example, if an estate includes a residence that needs to be sold, we would have filed the paperwork in court to get them the authority to conduct the sale. So they ultimately sign on the deed to sell the home and that kind of thing. They're the ones that are preparing the home to be sold, whether it's hiring people that the estate will pay for to clean out the house or paint it or do whatever they need to get that done. They're doing the sort of boots on the ground work, and they're having their probate attorney as a companion and helping them do what they need in court.
Okay. Thank you for that clarification. So after let's say that 4-month period is expired, no creditor claims have been made, and walk me through what are next steps that an executor should expect.
It's usually after that time period, if the estate has been liquidated or if some assets are being kept, regardless, that the final distributions can start to take place. We would help them in the process of creating an inventory and values for what all of those asset values are, and figure out what checks or property transfers need to happen to finalize the transfer. And then after that's done, we just file the closing paperwork with the court, and all is well.
Okay. Simple as that.
Yeah.
You make it sound so
Well,
painless, which is probably what your whole point is altogether. So
yeah,
walk me
it can be with a good plan. Go ahead.
and that was my next point is let's segue to a John Doe who has not made a plan. We just walked through what it would look like if someone had a will in place, had a good plan through probate. What does that look like if they don't have those planning processes in place?
If there is not a plan in place and the person has assets remaining after they've passed away that need to be transferred, and most certainly if there's real estate involved, this isn't 100%, there are always exceptions to everything. So, say generally what tends to be true, we end up looking to the laws of intestacy. So, those laws provide who is to inherit, who is eligible to be appointed as the executor or personal representative, and we commence the proceeding based on that. So, what it means is, as I said before, there's a mechanism in place, but at every step of the way, there are determinations to be made, and lots of people can disagree. And we may end up with the court having to step in at every phase of the process because people have different opinions, different rights involved before the steps can proceed. So sometimes what looks like it should be simple is not simple at all once people become involved and all have an opinion on what should happen and different rights involved. So that's inevitably why things get pretty expensive.
Yeah. So walk me through, you mentioned earlier that just not having a will in general may cause your assets to go in a direction you don't want. Can you give me an example of what that might look like?
They may have people that are very important in their life that aren't related by blood, for example. And the laws of intestacy are really driven. They come from ancient times and bloodlines and Old England and all of those concepts. So, first, under the laws of intestacy, we would look to a spouse, then we would look to children, and then what comes next? Parents, and then siblings, and then goes out to cousins, which maybe even by itself sounds somewhat simple, but all of a sudden you apply things like people having a half brother or sister, or things that are very inevitably people's lives are just unique. If we were all the same, this would be perhaps easy in some ways, but every family has its own uniqueness. Once you apply it through those formulas, it doesn't always come out how people want it to. Assets may land in a remote cousin's lap that the person never even met.
Right. Or
Yeah.
I've anticipated this with clients that the inverse could be true, where they do have a child that it would naturally go to, but they would like to disinherit, or they are estranged to and don't want those assets to go to. So it sounds like having a plan in place would just solve both ends of that issue.
Yes, and I'm glad you mentioned that because a big issue is planning for children, I would say. So if there's no plan in place, what will likely happen, even if, assuming the kids are to inherit something, they will probably receive everything outright by the age of 18. So most people, I would say, in today's world, don't think that their 18-year-olds are fully equipped to handle and make decisions based on a
Right.
fair amount of wealth.
Right.
So I would say that a very common plan for us, it's very unusual for us not to be planning for something that would extend the age in which kids would inherit assets. So it would be common, for example, to do something like a trust for children within people's wills
Hmm.
so that it doesn't have to be implemented until they were to pass away and they're free to, throughout life, edit it as they wish. So it's a testamentary trust, is what that would be. Anyway, it would include provisions, for example, for gradual distribution of assets. A trustee would be in place, a succession of trustees that they'd probably name, whereby they would be sitting in a role similar to what the parents had as the gatekeeper holding the checkbook or debit card or however you
Right.
want to say
Right.
it, and making decisions of what's best for the kids. It's not that the kids don't ultimately have the rights to the assets, it's that there's this gatekeeper in place deciding, is this the best thing for you right now? And so we have some really good language we use. Obviously, I adapt language to every client depending on their needs, but some really good starting places to make it efficient that even allow a trustee to withhold assets. For example, if a child has a drug addiction problem and it would be better that more money wasn't given. So there's a lot of creative work we can do with trust that we inevitably put into people's wills
Mhm.
to help navigate those various phases of life. And giving outright versus gradually is usually a big concern of parents.
Yep. No, I've seen that time and again. And sometimes, heaven forbid, their own spouse. Sometimes they want to set up provisions that allow that their surviving spouse to not outspend themselves and make themselves destitute. So I've seen that happen with clients, and maybe you have as well. Maybe I'll bring this back to our home base, which is more of on these misconceptions. What other topics do you usually see when it comes to meeting with you?
One of the big ones is trusts versus wills. There's a
Okay.
lot of misinformation out there. And as I touched on a little bit earlier, depending on the state you live in and the state's laws that apply, you may have greater incentive to do a trust in one state versus another. But thankfully, in Washington and Idaho, we don't have a lot of those overarching reasons to try and pursue a trust versus a will. Basically, a lot of the advice that we talk through with clients is related to what is more efficient. And we try and obviously implement the most effective, efficient, cost effective plan that we can. And for most people, that means that they will have a will, likely with trusts in it, but that they probably will not. I would say most clients do not end up with a living trust in place. And that can be part of the advice or conversation I have with clients always is I say, you will run into friends or others that say, you don't have a trust. What are you doing? You have a terrible plan in place.
Yeah.
Because there is so much misinformation out there. So I make sure to talk it through with them so that they can go forward confidently in life, understanding that, look, I have looked at your situation, the state you're in, the assets you have, and I'm familiar with, I handle probate actions. I handle living trusts as well, and I'm able to see firsthand over and over what tends to be the most efficient. And often it's not that it's never appropriate for somebody to do a living trust, that I wouldn't go that far. But I would say often what happens is when people create a living trust, what they're doing is almost the equivalent of, what is the equivalent of creating an entity that owns their assets even while they're alive. So what that means is they're paying all that sort of startup costs to do it, transfer by deed their home to the trust and that kind of thing. And then they have to manage that throughout their life in a way that the trust continues to own all of their assets. Inevitably, what happens is people forget to title assets in the name of the trust. And we end up doing what we call pour over wills anyway, because it's so common that people forget assets.
Yes.
So inevitably, we have to open up a probate action anyway. And then they've done all this work and the upfront costs of trying to avoid probate. We end up doing a probate anyway. So they've effectively paid twice as much, and it's been more of a hassle for them to get things resolved. When really people's goal, usually coming into the office, is I want to make things as easy as I can for my family. How can I do that? And that's what I want to help them achieve.
Sure.
So usually, thankfully, in Washington and Idaho, starting with a will is usually the best way to go.
All right, that's fantastic feedback. I agree with you. I see many times, I'm no attorney, but just this week I had someone come in who felt that almost ashamed to say that they didn't have a trust, and by no means was not in a position to need a trust, from my opinion. But from what I'm understanding from you, even when you do set up a trust, it's a lot of work to take care of that and manage it. And you only want to take on that responsibility and cost and literal lifetime of maintenance if your benefits outweigh the costs, right? And even then, as you mentioned, I also see many clients that don't fully fund the revocable trust, thereby not really taking on that solution the way that it was intended for in the first place. And inevitably, in your own word, it sounds like they end up having to take care of the trust and what they were trying to avoid all along, which was the probate. Am I understanding that right?
Right. Yep. That's a very
Yeah.
good summary.
So how do we fix that?
Education, I think, is the best. I like doing this and getting more of the honest information out there, if you want to put it that way, more of the accurate overview instead of guiding people so intensely towards this one tool that can be good, but in so many situations, it's less efficient and more expensive. That's not the direction I want to send my clients if I can help it.
It seems like there's almost an element, a level of prestige that comes with the word, I have a trust.
Yes. Yeah, and there are so many different trusts and ways to use those tools. And the initial information that people get about trust, it's usually related to revocable living trusts. And so those are basically what I would say that what we've been talking about for the past few minutes. I guess at the same time, I want to be clear that we still use trusts in lots of different ways, but only when we determine that to be efficient and advantageous, worth the costs, that kind of thing. So for example, like I was talking about trust for children, it is very common for me to put those kind of provisions within a person's will, which would only take effect after they were to pass away and if the conditions were met. For example, if you said, I want a trust to be in place if my children are under age 30. If they pass away and they're under age 30, it goes into effect. But by the terms of the will, if they're over age 30, then no one ever needs to create a trust. And again, that's just more efficient. We have all the safety nets built in to the best we can. We don't have a crystal ball on what's going to happen with people's lives, but to the extent we can anticipate and based on lots of years of experience, what we would want to have in place, we can do lots of creative things with trusts, and not only watching out for children, but doing various things to minimize the taxes that might ultimately hit the estates and things like that.
We're obviously picking on revocable trust because that's a low-hanging fruit most people think about, but I agree. What other elements are you finding that clients are overlooking or misunderstanding?
Another bit of misinformation that's pretty common out there is life insurance and how that impacts potentially estate taxes. People, I think, are perhaps rightfully confused with that because they hear that life insurance is tax-free. When that comes up, I think most references are to the fact that doesn't trigger income tax or capital gains tax, and that's great. But one of the things that people often don't realize is for estate tax purposes, whatever life insurance you have, the value of that is included in the size of your estate. So, for example, in Washington, where the state estate tax exemption is $2.193 million, as soon as somebody has $1 million life insurance policy, that eats into that exemption a lot. And then you add, as valuable as real estate is now, it doesn't take as long as it used to get an estate that exceeds that amount. So that's very interesting. And then if I could add to that a little bit, one thing I want to make sure people understand, because I think most people don't, and I would call this sort of middle America at this point, there are pretty straightforward tools we can implement using trusts within people's wills to make sure that both spouses in Washington, that their estate tax exemptions are utilized. And that's something that spouses would definitely want to have in place before either of them passes away, or they may lose the opportunity to do it. But basically, what it does is make sure that, because ultimately we're talking about an estate getting taxed, after one spouse passes away, there's an unlimited marital deduction that allows assets to go to the surviving spouse and not trigger taxes. However, what happens is that surviving spouse, their estate just got a lot bigger, and all of a sudden they're an individual with that's only eligible for one estate tax exemption. A pretty common planning tool that we or I implement is to put the correct trusts into wills whereby after the first spouse passes away, assets can be poured into that trust, thereby utilizing their estate tax exemption. And then the surviving spouse can even be the trustee of that trust, a beneficiary of that trust. So they're not precluded from using those assets while they're alive. So they get all those advantages, but they get this great estate tax advantage that can save them sometimes about $400,000 in estate taxes, just by making sure that these trusts are in place in their wills or however they do it before they pass away. In my experience, that's a pretty straightforward plan that a lot of, as I said, I consider it middle America at this point, is not that familiar with. And it would be nice to get that information out there. It is not as unusual as it used to be to have an estate that exceeds $2.193 million.
Definitely.
Yeah.
Definitely. And maybe if I can put my fifth grader hat back on, Robyn, if I could drill a bit deeper, help me put in layman's terms, what is the estate tax? What is exemption? And although not applicable in our state of Washington, what is the inheritance tax? I hear these terms thrown around and sometimes used in conjunction when they're not supposed to be. What are we trying to avoid with this exemption? Can you help drill that down to simpler terms for the audience?
Yeah. Thank you for that question. I guess one thing to help explain that a little bit is the kind of estate tax or inheritance tax or death tax or whatever at play depends on the state in which the decedent lived at the date of their death. So when we're figuring out what laws apply, that's where we start. So in Washington, there is an estate tax at the state level. And then all Americans are potentially hit by estate tax at the federal level as well. So for estates over the value of 2.193 million in Washington, an estate tax can be triggered, or they have estate tax exposure is what we like to say. Currently, the federal exemption is $13.61 million per individual. So very high. Most people don't hit that one, although plenty of people do. So we plan around that as well. But those are the two things in Washington that we're looking at. Now, Idaho does not have an estate tax or an inheritance tax. There's only the federal estate tax that's at play when you're a resident of Idaho. So really, the number we're focused on for Idaho residents is currently anyway, $13.61 million. And then add the 48 other states and
Yeah.
and all of their separate rules, that varies a lot. But I really appreciate that you asked that question about what is inheritance tax versus estate tax. It just depends on the state that you're in. And for us, it's the size of the estate.
Perfect. Thank you. And maybe just to drill a little bit further, correct me if I'm wrong, but when we're talking about estate in all of this, perhaps the most root word that we're talking about today, we're talking about one's assets, what they own and what they owe, right? What they own and what they owe, and making sure that all gets encompassed and accounted for. So when we talk about an estate size of 2.193 million, we're talking about is your house, your IRA, your 401ks, your property, your boats, your RVs, all those elements are all encompassed in that estate.
Exactly right. Everything
Okay.
you own or have an ownership interest in as of the date of your death. Yep.
Okay. Very
Yeah,
good.
and the outlier, the quirky one, like I mentioned before, is the life insurance. Because while you're
Right.
alive, you don't feel like you have that asset because you necessarily don't have much value in that asset.
Yeah.
While you're alive, it takes a lot of value when you die because that is what it's for. But that is also included too.
And maybe I can cue you up here for this, Robyn, but how can one leverage life insurance as a tax-free asset upon death for those estates that are over those exemptions that don't want to include a life insurance proceed as part of their estate upon death? What can they do?
Yeah,
How
so
might they leverage that? Because there are some people that may be listening that are more educated and say, wait, no, I thought there was something out there that is good to have life insurance upon death. Can you expound on that?
yes, great question. Yeah, and this is when we dive a little deeper into the land of trusts, right?
Yes.
So
Yep.
this isn't very worth the cost, time, effort, expense, all the things in order to implement. So it would be very common for me in my office and my colleagues to do what are called, we call for short ILITs, but irrevocable life insurance trusts. The impetus for doing that is to try and remove that life insurance from your estate. And it can be a little bit of a tedious process because there's some hoops to jump through in order to do it. But basically, you're creating a trust that you cannot revoke, that owns the life insurance policy and is the beneficiary of the life insurance policy, such that at the date of your death, you don't have an ownership interest in it and it doesn't trigger the estate tax in your estate. For example, what we might do for the higher net worth clients or a component might be we assess what their estate tax exposure is, and say they own a lot of businesses and they want to be able to pass the businesses down to family members or something, and they don't want anything to have to be liquidated in order to do that. What they may do is take out life insurance and we'd put it in an ILIT such that it would be enough to pay off whatever estate tax liability would be anticipated, but it also wouldn't increase the estate tax liability at the same time. So it's a very efficient mechanism in order to maximize the value of their assets and maximize what they can transfer down to their whomever they're leaving it to, but let's assume it's their descendants.
Sure.
Yeah.
No, that's fantastic. Thanks for highlighting that. What else would you like to make sure we go over?
I guess we maybe touched on it a little bit, but talk about estate planning, not only planning for death, but also for decline. I think I said earlier, think of estate planning as creating a tool belt for people with all these tools in case this happens, that happens, you're prepared.
Sure.
And then as part of that, I like to do, or I recommend for clients, and very commonly do, powers of attorney, whether it's for financial matters, healthcare, all of the above. I do living wills, sometimes called healthcare directives, where people are setting forth healthcare wishes. People get to take the opportunity now while they're able and make those decisions. They presumably know best what they want. It's more efficient for them to have decided and put it down to the extent they want to. And also, it can be a gift to family members to have created a plan where they've said what their wishes are, so people aren't wondering at a very inevitably difficult emotional time. If there's some health crisis going on and people are guessing what their loved one might want, emotions are already elevated. People may end up with strong opinions one way or another, and then a situation that's already difficult becomes exponentially more difficult.
Yeah.
So, to the extent that people can set up a plan and set forth their wishes, I feel like it's actually a very big gift to their loved ones to leave that behind. So,
I like that term, gift. I hear the opposite many times, that clients come in and say, I need to get this fixed because I just went through a year of heck taking care of my father's estate. And it is a very emotionally charged time, like you said. And people hopefully only go through it once or twice in their life. But just to give them that gift, as you said, to give clear orders so it's not one more thing they have to spend emotional energy on, I think is a great way to put it.
good summary. Thank you.
Yeah. I've got another question, Robin, that comes up so often with my clients. And it comes down to, I have enough money for my needs and my wants in this lifetime. What are the implications or considerations I should make as far as giving to my children now? Say, I have my lake cabin or my own house. I want it to go to my kids. Why don't I just give it to them now? Wouldn't that be a wonderful thing? Why should or shouldn't I do such major gifts in my lifetime as opposed to upon my death?
Boy, that's a great question. And yes, it's a great opportunity to touch on too. One of the big drivers for that is estate tax exposure. And so there can be really good reasons to start doing those transfers during life so that what remains in their estate is necessarily less and less subject to estate taxes. And we have lots of good mechanisms for that. At the same time, of course, I like to not lose track of the fact that people are talking about their family and what is the best for their family. So while we can sometimes get distracted on minimizing taxes and estate tax exposure and geek out on that a little bit, truly, I like to encourage people to maintain throughout the process. But yes, is this good for my family? For example, sometimes if your kid's, I don't know, 20 years old but your estate is large and you're dying to get assets out of the estate so you can minimize your estate tax exposure, maybe the 20-year-old isn't ready to own the lake cabin. Yeah, we might not be there.
Yeah.
So those can be just interesting conversations talking about timing and what you might want to do gradually. But also, people should know we have some really good tools in place, like we call them QPERTs, Qualified Personal Residence Trusts, to be able to transfer a primary or secondary residence at reduced costs. And that's a little bit involved for this conversation, perhaps, but those tools are there. And I would really encourage people to start having those conversations. For example, if they listened to this presentation and started realizing, or maybe they knew they had a fair amount of estate tax exposure, anything over 2.193 million in Washington, then they want to start thinking about these things. And I would recommend that they visit with an estate planning attorney and start having those conversations. It doesn't mean they have to do anything or everything all at once. It's very common to start a transition. In this phase, for example, these next 3 to 5 years, we think XYZ would be a good plan. When our kids are a little older, let's revisit this in 5 years and see if we want to do another thing and tweak this a little bit. Or maybe then we're comfortable doing a QPERT where we're gradually giving over ownership to the house or vacation home or whatever that might be. And phasing through life like that makes a lot of sense. And actually, incidentally, highlights why it's more efficient in most cases to have a will in place than a trust. When there's a living trust in place, every time we do an amendment, we have to look at what's there and assess it and what powers are remaining, do a full-on assessment of what's there before we can do anything prospectively. When we're working with wills, we start with a blank slate and say, okay, great, we did that last time, but what do we want done now, regardless of what was done? So it's just a more efficient way to go forward in planning. And I think will better inevitably meet the needs or desires of people that are implementing plans. It's easier for them and more cost effective to update every 5 years than it otherwise would be, or whatever fits their needs.
Sure.
Yeah.
No, and I think that's a good point. I see clients get intimidated by trying to meet with an attorney, not just the first time, but saying, "Oh, I need to amend this, and I've gotta go back," and they get intimidated. They think they're gonna get nickeled and dimed just for ringing the phone. But you add another level of just validation why a will is that much easier and efficient to say, no, I can come back and I can do a full remodel if I want. And it's that much less costly and much more efficient because, again, like you mentioned before, when you create a trust, you got a whole nother entity, right? Another person there. You got to file taxes for it. You got to babysit it. And for better or worse, if you don't change it, it's going to be set in stone. So I can agree with you 100%. I think many clients would better benefit from a will rather than a trust, but it doesn't mean that there can't be a trust within the will. So again, depending on everyone's situation. Yeah.
Lots of variables.
Lots of
But
variables.
that's a good core assessment.
It's what keeps us employed, right? If it was all
Right.
super simple, then
If it was
we wouldn't
easy.
have a job. Yeah.
Yeah. I would say this too. It's so nice when sometimes people come in dragging their feet a little bit. My financial planner told me I should do this. I know I should. I've been avoiding it for years. But they finally get in through the door, right? Inevitably by the end of the process they feel so good, surprisingly good. I don't think that they anticipate they'll feel that good. It's a weight is lifted off their shoulder. They feel really good about the plans in place, or that's always my goal, and I think we land there. And so when they walk out, they know what they've been able to do for their family even after they're gone. It's just another potentially an expression of love, right? Even after I'm gone, I care about you, and these are the things that I want to make sure are available to you, or these are the
Right.
causes that I care about very intensely, and I want to make sure these donations are made and these are supported even after I'm gone. Talk about adding value to all of your hard-earned money that you've made or wealth throughout your life. I think it ends up being very satisfying.
Yeah, I would agree. I feel I get the same benefit when I work with a client that thinks that they are on the brink of poverty. And then by the end of the conversation, they realize that they need to start planning some vacations because they just needed to plan smarter and not work harder on it. So I think that's a good way to put it.
Yeah.
And maybe if I can
Yeah.
expound on that, Robin, as far as this whole theme of misconceptions goes, what can someone expect when I know every attorney is different, but just picking on you, if they were to
Sure.
work with you for the first time, what can they expect in that initial phase, even before they walk in the door and throughout that first conversation, just so they have an idea of what
Yeah.
to expect and it's in that proverbial dentist office.
Yeah, yeah, great question. Thank you for asking it. Yeah, usually what I do is I send a data sheet to clients, just email it before we meet so they can fill out some of the basic names, addresses, birth dates, professionals they work with to the extent they have any. They'd name you on it, for example, if you're their advisor or insurance agents, that kind of thing, and some sense of what their asset makeup is. That doesn't have to be perfect. Mostly I'm concerned about the character of the asset and an approximation of the value. So a lot of people will come in without any print offs or statements or whatever, and that is just fine. Obviously, we're working into the future anyway, so we don't need anything down to the penny.
Mhm.
Anyway, I send that data sheet and then they bring that information to the first meeting. And I usually block off 2 hours for that first meeting because I really like to get to know people, their interests, talk through everything, go back and forth on ideas. And for most clients, that ends up being the most substantive meeting because we're
Mhm.
really going through everything. And usually, before that meeting's done, I've made recommendations on what their plan should be, given them a sense of what that might look like. And then they're just deciding afterwards whether they want to go forward with having me implement it or not. It's usually after that initial meeting that I'll send the engagement agreement, can even send it by DocuSign or whatever, where they agree I can represent them. And
Mhm.
then, in whatever parameters they want this work done, not that work, whatever. And then we go forward from there. And then it's whatever is most convenient for the client. I would say for most people, having the next phase be me emailing them draft documents is something that works very well. Or if they prefer mail or they prefer to come in, that's just fine, however we do it. And then they take their time looking at drafts, and I try and spare them too much anguish over the legalese they'll find in there, but make sure that they're get a sense of what it looks like all put together and can ask whatever questions they want. And then we'll do whatever we need to do to fine tune it, however many times back and forth. And after we have the documents ready to go, we schedule the signing at our office. And then we offer to keep the originals in our will vault, and we send them a portfolio of copies of the documents. And then, as the phase after that, or I consider an added phase, is me working with their financial advisor to coordinate things like beneficiary designations and make sure that those correspond and support the plan that we're implementing. Because, and actually, this would have been a great misconception to talk about. Sometimes people think that a will or similar will absolutely dispose of all of their assets, and that's not necessarily true, as some assets transfer according to beneficiary designation. So it's very important in doing estate planning work that I look through everything and I end up making recommendations as to what their beneficiary designation should be on various
Mhm.
assets. And then they go back and work with their planner. And sometimes you and I will connect and make sure you have the right information, that kind of thing, and put the plan into place. And then they get to be on cruise control for a bit until something changes that they know they want to change, or they
Yeah,
just want to do an annual review or something like that. That's what we do. Yeah.
fantastic. Maybe a comment and then a clarifying question. The comment is, it sounds just because you signed on the dotted line at the end of the day, your estate plan is not necessarily 100% complete. Maybe you need to go back and retitle some assets, update beneficiaries that obviously you can't control for them. Is that fair? Is that a fair understanding?
I would say if we're talking about a will, it's probably not retitling assets necessarily,
True.
but the
No will not.
beneficiary, yeah, the beneficiary designations definitely. Big considerations that people don't normally realize are retirement accounts, 401ks, life insurance. Those are going to pass according to the beneficiary designation. Worst case scenario is somebody leaves an ex spouse on them or something like that, where nobody anticipates the assets would go that direction, but they didn't bother to update. Part of me doing estate planning work with people is trying to make sure all those ends are tied up and they have a complete plan in place.
Fantastic. And one other
Yeah.
question that kind of piqued my interest as you were talking about the initial conversation. It sounds like clients don't need to feel like they'd have to come to the table with you with all the answers and the full plan. Rather, it sounds like that 2 hour discussion is more about what are the questions and what are the answers. So they
Yes.
shouldn't feel like it's a barrier to them starting the process because they haven't got all the answers yet. That's literally part of your process with clients. Is that a fair
Yes,
understanding?
thank
Okay.
you for pointing that out. Yes, I
Okay.
think so. I think that's one of the reasons that give pause to meeting, because they feel like they should. And I, like on the data sheet I send people, it asks some of the questions at the end of the form. Who do you want as executor? Who do you want in these various roles? And what I tell people is you don't even need to answer those at this point. We will work on that together and talk through it. Because until you understand what roles you're nominating people for, it's really hard to decide who is the best for
Right.
those roles. And so I like to describe that, things that would make it more convenient, or certain traits that might work better as an agent under a power of attorney for health versus a power of attorney for finances. A
Right.
lot of times people will have named different successions throughout different documents just because of people's skill set or geography, things like that. Yeah, we talk through all of that to make sure that they understand and can be confident they're picking people that are the best choices in their life.
Fantastic. Thank you. I ask because I know some clients feel the same with me. They feel like they can't come to start the conversation until they have every financial number they can think of. And it's more about discovering the process and what we need to do rather than a one and done type conversation or phone call.
Yeah, yeah,
Yeah. Thanks for
that makes
highlighting that.
sense.
Well, if people have additional questions that we obviously didn't have time to cover today, what's a good way for them to get a hold of you?
I am at a firm in Spokane called Douglas Eden. You can see my name is Robyn McGinnity. You should be able to find us on the internet, but the number's 509-455-5300, and you can find me there.
Fantastic. Thank you
Thank
so much
you.
for your time today, Robin, and your expertise and applied experience. It's been really helpful, and I really enjoyed the conversation.
I did too. Thank you, Taylor. You have a
Awesome.
great day.
Thanks, Robin. Take care. If you found today's discussion enlightening, please subscribe so you can receive additional updates of the interviews I'll be conducting with other attorneys, real estate professionals, mortgage brokers, Medicare brokers, and more professionals that are all designed to help you retire well. Thanks, and I'll see you in the next one.